There have been various twists and turns in the case against 5 men accused of killing Bafana Bafana star Senzo Meyiwa. In the latest installment, Adv Zandile Mshololo asked the court to postpone the cross-examination of state witness Sgt Thabo Mosia to allow her to read what has become known as the second docket. Now, this is not the first time we have been hearing talk of this second docket. Now, in this particular second docket, we do understand that the people who were inside the house, including Kelly Khumalo, are said to be responsible for Meyiwa's murder. And at the same time, of course, in the first docket, we do know that it's the 5 men who are in the dock currently who stand accused. Let's now look at the legal implications of all of this with legal analyst Mpumelelo Zikalala. Kuzen, thank you so much for your time this evening. On the face of it, the lawyers are arguing that there appears to be a cover-up here. Could they be correct?
Good evening to Mangat and also to the SABC viewers. It could be, however, we'd leave it to the NPA to discuss this type of issues. But what is important for the NPA is to say, why wasn't this particular docket analyzed? If it was, what warranted those witnesses which are going to be called into the witness box to be called, and what basis and what analysis did they use to say that the others must not either be charged or be called in as witnesses? Maybe what the NPA can then say is to say, remember that you are the dominant leaders in this particular matter. We may have information that you don't have, and we do believe that if we bring a case with the 5 accused or the current 5 accused, we are going to be successful in getting a conviction. So it doesn't matter what actually lies on the second docket. You may use it if you want to. However, we do believe that we have a strong case, but they have to ensure that that happens, because if they fail to prove a conviction in this matter, it's going to be very detrimental, firstly for the brand or the image of the NPA, but mostly for the Meyiwa family, because they would have never found out the truth as to what happened to their beloved son.
So what then, in your view, given all these arguments you've just put on the table, become the complications when it comes to proceedings going forward?
I think from the NPA side, they have to sit during the course of this weekend and say, let's compare the 2 dockets and see what we can use in both of them. If there are additional individuals that have to be charged, let's bring them to the witness, to the accused box and prefer those charges against them. It's not too late. There's only one witness who's in the witness box who hasn't finished in terms of giving their evidence. Either the new representatives who are representing the other people who are going to be charged can listen to the records or even read the transcripts, and if they have to, they can even conduct their own cross-examination. So it's not too late for additional accused to be brought in. Or the NPA would then say, no, in fact, we believe that we have incorrect individuals. Let's not waste the court's time in terms of trying these individuals, knowing very well that we're not going to get a conviction. Let's rather go back to the drawing table and say, in the investigative past, we must have missed a few things. We might have made a few blunders. Let us make sure that we redeem ourselves now. The most important thing is that at the end of the day, you must be able to find who is the perpetrator or the killer, so that they're able to be brought to book, and that for the Meyiwa family to reach some sort of finality and to be content that at the end of the day, they found out the truth as to what happened to their son.
So listening to you then, if they don't do this due diligence, this work that you say they must do this weekend, next week we could then see a postponement when it resumes, if there are still a lot more questions about this particular, second docket.
Definitely there could be, either from the NPA side, in which they would say, Judge, please give us enough time. We need to go and prefer more charges to other individuals. Or they would say, we want to withdraw the charges against the accusers that are in the witness box. In that case, because they've pleaded already, they can't be brought back again and be charged with the same crime. That's equal to double jeopardy. So they would be let free. But for the defense, then they would come back if the current accused continue. The defense will then say, I want to use the content of the second docket in my defense, because at the end of the day, I so believe that it's going to assist me in reaching or in supporting my defense. Let's remember that despite the fact that it does not form part of the docket which is being used now, it was a statement which is said under oath. So you're still at liberty to call that particular witness into the witness stand and say, in a particular point in time in your life, you sought to tell the truth and nothing but the truth, and you said the following things. I want to repeat this evidence in front of this judge so that you can be able to prove that my client is innocent and did not participate in all the things in which it has been alleged that they participated in. So it's important for the NPA to make sure that they need to regroup and maybe restart and say, is our strategy the correct one in this particular matter, or do we need to relook at it? If we don't, we may have a problem, because at the end of the day, we're not going to get the conviction that we want. And we are going to let the real killers go free.
So one of the things that also then this brings to the spotlight again, I remember when the trial was resuming, there were concerns and even questions, and I even remember speaking to Kelly Khumalo's lawyer, for example, and she was not even clear as to whether or not her client would be a witness, would be an accused. There's still no clarity around that. That also further adds another complication, because some of the lawyers could argue against some of their clients being brought in because there was no clarity to begin with.
That can be done, or that may be an issue. However, they can be cured at the end of the day. If you can substantiate why you are bringing this accused at such a late stage, then the court may say to you, no problem, we are going to grant your application, because at the end of the day, you want the truth to be known. What it does, though, it focuses on our law enforcement officers and also on the NPA. The first question that we need to ask is there collaboration between the two? Are they able to work together to make sure that all those perpetrators and all the individuals that belong to behind bars are able to be sent to prison by our courts? Secondly, from the law enforcement agency side, do they really know what they are doing? Do they understand the consequences of not being able to investigate a matter to its finality, or not being able to investigate a matter in its proper manner? If they don't, it is not only their job which is on the line, it's not only the brand of the law enforcement officers and the NPA which is on the line, it is the integrity and the lives of all the perpetrators and the victims of crime, because at the end of the day, they might not get justice at all, not because the truth was not being able to be found, but because the law enforcement agencies are incapable or are failing dismally to make sure that they execute their duties in a manner in which they ought to execute them in.
I suspect we're going to speak again on Monday, Kuzen, given how things might unfold in the next couple of days. But let's leave it there for now. That is Mpumelelo Zikalala, a legal analyst, looking ahead, of course, to the Senzo Meyiwa trial happening next week, and also the developments that happened this week.